Welcome to My Hometown, the program that explores clubs, organizations, businesses, and issues across Nassau and Suffolk counties and sheds light on the different towns that are making a difference.
Hello and welcome to My Hometown. I'm Bill Horan, along with my co-host, Stacy Raine.
Bill, today we're going to learn about elder law from the people at Cona Elder Law here on Long Island. Their practice concentrates in the area of elder law, estate planning, estate administration and litigation, special needs planning, and healthcare law.
Our guest today is Kristi DiPaolo. She's the Senior Associate at Cona Elder Law. Kristi, welcome to My Hometown on the voice of Nassau Community College, 90.3 WHPC.
Thank you for having me. I'm happy to be here.
Kristi, when I think of elder law, the first thing that pops to mind is when people are getting scammed, when elderly people are targets of scams. But there's so much more to it than that. Is that right?
Yes. So, we're an elder law estate planning firm. So what elder law issues deal with is really issues affecting the elderly, right? It can be scams. It can be asset protection planning for long-term care, planning, for your needs once you get older, setting up documents, but also, if you don't have those things in place, guardianship proceedings. So it encompasses more than just the estate planning aspect of, estate planning.
Okay. Now, Kristi, what got you to specialize in elder law? We hear people, they go to law school, they want to be criminal lawyers, or they want to be corporate lawyers, make a lot of money, wear a nice suit, and have a fancy office. Did you just happen to fall into this? Was this something you were always interested in?
This was something I was interested in. I was, before I became an attorney, a legal secretary for many years.
Oh,
and
wow.
One of the attorneys I worked for did this. And
Okay.
he kind of inspired me to go to law school.
Those are the best lawyers. Seriously, I'm a retired lawyer. The people who spent time as a legal secretary, because they know all the ins and outs and even the things the lawyers don't know.
Oh, yeah.
Yeah.
Law school was a breeze for you.
Oh, no, I wouldn't say that. But this was,
the cake.
this was the area that I always wanted to do. I feel like I'm helping people. I like to work with people and accomplish something for them and have
And you
them
really
feel good.
are, and this is such a key area today. I mean, everybody wants to be an elder. The alternative is not making it to elder law.
Right.
So you want to, but there are so many issues that now come up with different marriages, multiple marriages, children from different marriages, children out of wedlock. So many issues that have to be addressed that your firm must be doing a tremendous business.
Yeah. I mean, people are living longer. I have many clients even in their hundreds. And we have to plan for all areas of life and phases of life. So, it is an important area.
Definitely.
Right. In estate planning, there's a lot to it, but it is something that sometimes people don't think about, and they really should. You hear a lot of news stories that I think it was Prince who didn't have a will, right? And everybody's like, how do you not have a will? But it's so important. And not just people like him who have tons and tons of money, but
Right.
everyone really needs to have be thinking about estate planning. Is that right?
Yes. I always say at 18, there's estate planning you can do. There's certain documents you can have in place.
Wow.
Like a healthcare proxy power of attorney. Once you're 18, you're an adult. Younger people, I hear that a lot. Younger people with young children. Oh, I'm young. I don't need to think about it. But that's not true. Wills are the only way you can designate a guardian for your minor children. So
Right.
it's important at that aspect of life. People looking to retire. Maybe your will you did 20 years ago isn't going to work for you now because you want to think about long-term care planning and different needs that you may have for the future. So it's not, and everyone has assets. Everyone, whether you have $2,000 or $2 million, it's an asset that you want to make sure it's going to go where you want it to go when you pass away.
Right.
Kristi, what are some common misconceptions that you find when people come in and they just either don't understand it or they're thinking in the wrong direction?
Kind of to follow what we were just previously talking about, that they're too young to do estate planning, which isn't true because there's things you can do. For example, young families with children, that you don't have enough assets. If you have some assets, it's something you can protect and plan for. A lot of the time I have people come in and say, well, if I die, my assets, if I'm married, are going to go to my spouse, so I don't need to worry about having a will. But that's not true. If you have a spouse and you have children, your children are entitled. Not everything goes to your spouse. Another misconception I get is with not so much the wills and the trust is what we think about, is with decision making, healthcare decisions and financial decisions. If something were to happen to you, if you're incapacitated, just because you're married, your spouse doesn't have legal authority to make those decisions on your behalf. So then your family is stuck and you have to do a guardianship proceeding, which is more costly, and then the court is involved. So there's all different aspects of planning that you can do that people don't think about till they come in. We talk to them and tell them the risks, the options, and then, they understand.
I like that you just said that people don't think about, because that's one thing. When my husband and I wrote our will, we had to talk about really serious questions that we probably wouldn't have addressed had we not started to think about these things. If something were to happen to both of us, what do we want to, who do we want to have guardianship of our children? There's so many little things. Or if something were to happen to me, how do I want my medical treatment to proceed?
Right.
Things that are really kind of uncomfortable to talk about. Sometimes it's nice to have someone in the room to guide those discussions, but things that we don't want to think about but are really important, for the just in case type stuff too.
Yeah, absolutely.
Kristi, we in the terms of elder law, people I know come to you to protect their home and for long-term plans, etc. Can you address that a little bit? Because I've heard some horror stories about that.
Yeah, so, we do planning in the event you're going to need long-term care in the future. Most people, everybody's living longer, and more than half of us are going to need some sort of long-term care, which is, we might need aides to help us at home, or an assisted living, or a nursing home. So that's very costly. And there's only 3 ways to pay for that. It's out-of-pocket, long-term care insurance, or Medicaid. A lot of us don't have the money to pay for it. You could wipe out your hard-earned savings. And if you don't have a good long-term care insurance policy, they get very expensive as you age. So a lot of our clients are looking to the future thinking they may need Medicaid or which is governmental assistance to help pay for your care. So hopefully you come to us soon enough where we have time to plan ahead. We can protect your assets. Most of the time, the biggest one is a house, through setting up a trust. But it has to be the right type of trust. Unfortunately, I have people come to me where they've done planning in the past and it wasn't the right type of trust and their house wasn't protected. Sometimes I'll have people come to me and say, well, what if I just give it to my children? But there's risks with doing that, because now it's your house owned by somebody else and it's a liability if God forbid, they get sued, right? It's something they can come after. So,
interesting. I never thought about that. Are we starting to talk about the differences? There's the different types of trust, like revocable and is that what you're talking about? Oh, okay.
So would you like me to delve
into
those a little more? Okay.
Teach us a little bit about that.
Sure. So the way I always explain a trust is it's a bucket that holds whatever assets you put in there. And we create the trust agreement, which is the rule book for the assets in the bucket.
Okay.
And, you're the creator of your trust. Independing what type of trust it is, you may or may not be the trustee. The trustee is the manager. For irrevocable trusts, which are the types we do for Medicaid planning and asset protection planning, that's the type of trust we'd put your house in. You can't be the manager of that trust because you have to give up some control for it to be eligible as an asset protection trust. That's an irrevocable trust. A revocable trust is more for, if you have assets in multiple states or if you're looking to avoid probate or kind of consolidate everything in one bucket. But the assets in the revocable trust are treated as if they still are your own. So you can touch them. You can be the manager of that trust. You can put things in, take things out. But it doesn't provide any type of asset protection for long-term care purposes.
Kristi, I just want to back up a little bit on that. First of all, if I'm correct, there's something like a 3 or 5 year time span that if we're going to do this, we can't wait till the doctor says, well, get your plans in order in 30 days. Not going to work.
So it's what's called the 5-year look back is what most people have heard about. That has to do with nursing home Medicaid. In reality, what that means is if you're going in a nursing home July 1 of this year, and you need to apply for Medicaid because you can't afford to pay a nursing home because they can run you $15,000 to $20,000 a month, and you're going to decide you're going to apply for Medicaid. When you apply for Medicaid, you're only allowed very minimal assets, and you have to submit 5 years back worth of financial information when you apply Medicaid. So that's the 5-year look back. So if I was applying for nursing home Medicaid July 1, 2024, I would have to submit my financial information back to July 1, 2019. in that window, they're looking to see, did I move any of my assets? Did I transfer them? Did I put them in a trust? Did I give them away to one of my kids? Did I give something of value away and I didn't get that value in return? If you did, it causes a penalty where you would have to pay privately for nursing home care out of your pocket first before Medicaid will pick up the tab.
Now, I'm just going to interrupt, if I may,
Sure.
and say scare me. When you say you pay out of your own pocket, we're talking about money that millionaires don't even have in some cases.
Yeah, it can
right?
run $15,000 to $20,000 a month.
A month, you said?
A month.
Now, let me do the math. If we translate a month to a year, that's almost to $200,000, anywhere from $150,000 to $200,000
Yeah, it can be.
a year, or over 5 years, $1 million.
Yes.
You got that in your pocket?
A lot.
Stacy, you have that in your
I
pocket?
wish.
Come on,
I
I'm
wish.
looking at my pocket, and it's jingling, but I don't think it's going to come up to anywhere near that. So
Right.
I'm sorry. I just wanted to make that point.
No,
'cause that's shocking.
Right. And people, I don't know that everyone realizes or understands, the extent of the cost. So what we're talking about with the 5-year look back is we want to set up a trust well outside that 5-year window. So
Right.
hopefully you set it up 5 years down the road past. Now those assets are protected and Medicaid can't look at them anymore. So 5 years and 1 day after you set up that trust, you now need a nursing home. Well, now your house or whatever assets you put in that trust are totally protected.
Right. You are listening to My Hometown on the voice of Nassau Community College, 90.3 WHPC. I'm Stacy Raine here with Bill Horan, and today we are learning about Cona Elder Law here on Long Island. Their practice concentrates in the areas of elder law, estate planning, estate administration, and litigation, special needs planning, and health care law. Our guest today is Kristi DiPaolo, a senior associate at Cona Elder Law.
Kristi, I just want to go back and bring forth too. Is there a negative side that people would be afraid to change, that they have to change the deed on their house?
Correct.
And if I understand it correctly, though, it's almost more of a mechanical type of thing, where you're changing it from John and Mary Smith to the Smith Family Trust.
Correct.
And there's really no other downside, or if there is, please tell us.
No, I mean, I always tell clients there's really no harm, no foul with putting the house in a trust, because the trust says you have the right to live there during your lifetime. So no one can kick you out. And you have the right to any tax benefits that you're getting. So if you ever get any star or any veteran senior discount, you get to keep that. If you ever wanted to sell that house, you can still sell it. The trustee of the trust would be the one who would have to sign off, but you could sell it. The downside with that is if the proceeds of the sale would have to go into the trust, and you can get income from those. You just can't touch principal. So, I have clients say, well, what if I want to sell my house and downsize? Well, you can sell the house, the trustees, buy a new house in the name of the trust. If you wanted to sell and maybe rent, you could invest the funds from the sale and have it generate income, which can help you pay your rent. So you're entitled to access income from any assets in the trust. But the caveat with those type of trusts, because they are asset protection, you can't touch principal of the assets.
And that's why it's important to have an attorney like you who knows this stuff inside and out, because it's going to be very disappointing if we take a step and just find out something
It wasn't correct.
thinking, but was
Right.
incorrect. Now we're stuck.
One thing I know that sometimes you have to do is you have to decide who gets. You have to pick somebody for when you're planning your estate. You have to say you're going to be the person that's going to manage my be in charge of decision making during my life or after I pass away, or you're going to be in charge of a trust. How do you pick that person? I feel like you are going to have the best advice for this.
Okay. Well, first they have to be an adult, so they have to be over 18. We usually recommend a little older. It has to be someone you trust, right? It should be someone that you trust, maybe a family member, a friend, or a trusted person that is going to be able to take care of these duties. They also have to be responsible and being able to manage what duties you're giving them. A power of attorney is a person you're giving authority to help you with your business and financial affairs. That may not be the same person that you want making healthcare decisions for you. That's a different document. That's someone who's going to make decisions when you can't speak for yourself to the doctor. I have clients that come in because as part of the healthcare decisions, they can make end-of-life decisions. And I have clients that come in and say, my spouse couldn't honor my wishes and make those decisions, if I didn't want any further treatment or to take me off a ventilator. Maybe then that's not the person to name as your healthcare agent, know?
I'm going to make some problems now. Is that all right, Stacy?
Oh,
I haven't made any
always
problems
do.
today. I've been good. But let's put Kristi on the spot. If I have a power of attorney, what do I need a will for and all this other stuff? Am I just making you rich?
Nope, because the power of attorney is only valid while you're alive.
Oh, nuts.
Yep. So when you die, that document extinguishes as well. So the power of attorney has no authority to do anything.
So up to day of death, but commencing on day of death, then if I don't have a will, even if I appoint my daughter or my wife in charge of things,
it doesn't.
They have no.
There's no legal
power.
Exactly.
Okay, excellent point.
So I'm going to switch gears a little bit. I had a friend who's they had some challenges with her grandfather who was being scammed by somebody. I don't remember who it was, but he was slowly giving away all his money, and they started to think maybe he's not. They talked to him about it. They did all these things. And they started to think maybe he's not able to make decisions for himself anymore. What do people who are in that situation need to do? Do they need to establish some sort of guardianship, or what happens in that situation?
Yeah, you would have to, if someone has lost their capacity to be able to make decisions and they don't have healthcare proxy power of attorney in place, then the other option is you can bring a guardianship proceeding. Anyone can bring it. It doesn't necessarily have to be a family member. It could be a friend, a trusted person. But what you are doing is seeking permission from the court, basically, to make decisions for this person, whether it be business and financial or healthcare decisions, because the court has determined they don't have the capacity to make those decisions themselves. It's a legal proceeding, so you have to hire an attorney. You don't have to, but it's advised to hire an attorney. You petition the court. They're going to appoint an attorney for the person who we're asking for the guardian for. They also appoint a court evaluator who is an independent attorney who kind of is the eyes and ears for the court. And there's a hearing where the individual you're saying has lost their capacity has the right to show that they have not, or for the court to see them to help make their determination.
That feels like a very sticky and tricky situation.
Yeah.
That's why you want a firm that knows what they're doing,
Right.
like the Cona Law Firm. Kristi, there's the term which sounds funny, the living will. So if we're making out a will, we better be living, otherwise we're a ghost, right? But just to differentiate, we make out a will that'll take place once we pass away, as we talked about before. The living will, where does that come into play, and what are some things maybe we should know about that, or again, misconceptions?
So a living will, I myself don't love the name of that because it does confuse people. The living will is really a healthcare document. It goes with the healthcare proxy.
Okay.
So a healthcare proxy is a document where you're naming someone to speak to the doctors on your behalf when you can't speak for yourself.
Okay.
And they can make decisions regarding treatment, pain management, end of life. The living will is the guideline or the instructions, the guidance to your healthcare agent when they can make those end of life decisions. When you would want them to stop treatment, make you comfortable. What triggering events occur where they can make those end of life decisions.
So one says, I'm giving you permission to do this, and the other one says, but here's what I want you to do.
Right.
Yeah.
The healthcare proxy is the legal document. That's what you hand to the doctors. That's who is given the authority. The living will is more the guideline to that person. But I always tell my clients, it's an uncomfortable conversation, but it's a conversation you need to have with your family. Whoever's named as your healthcare agent, what your wishes would be so they can honor them at that time.
A lot of these conversations are not fun, but they're really important to have, and sometimes it's nice to have a specialist in the room. So I want to talk about that. There's lots of lawyers that know law, but why is it so important to go to someone who has elder law specialties?
It's important because, at Cona, that's all we do is elder law estate planning. So we look at your planning with the full picture, from the beginning to the end, because we deal with all aspects. So we know if something isn't done properly, end up in litigation, what the potential results can be. When we do powers of attorney, unfortunately, this is what I see a lot of the time because I myself do estate planning, Medicaid planning, is our powers of attorney have certain language, certain things have to be in there for them to be able to do it, to do Medicaid planning for you in the future or do certain things. A lot of the times I'll see people who did a power of attorney online, which makes me very nervous, or they went to maybe a general practice attorney, and it doesn't have all that stuff that we need for them to be able to do certain Medicaid planning or their asset planning. And if they have lost their capacity and can't do a new one, then we're stuck. So it doesn't always, the end result isn't always what you may wish, you know. So we kind of look at everything the full circle.
I'm going to take a minute to remind our listeners that you are listening to My Hometown on the voice of Nassau Community College 90.3 WHPC. I'm Stacy Raine here with Bill Horan, and today we are learning about Cona Elder Law here on Long Island. Their practice concentrates in the areas of elder law, estate planning, estate administration, and litigation, special needs planning, and healthcare law. Our guest today is Kristi DiPaolo, a senior associate at Cona Elder Law.
Kristi, I was just thinking of a joke when you were answering the previous question. I was going to say, since you deal with elder law, you must have a sign outside, no one under 60 may come in or something like that, like the rides at the amusement park. But then I realized maybe it's not the elder person who comes in to see you as the client, but either a friend or their son, the daughter, the wife, brother, etc. So can you talk about that? Who really comes in most times to see you? Is it the elder person or a member of their family?
It's a mix of both. Sometimes I'll have the kids come in and say, Mom's not doing well. She fell. We think she needs care. We need to apply for Medicaid or take a look at her planning. Sometimes I'll have the people maybe over 65 saying they're looking to retire. We want to take a look at their plan, maybe start asset protection, setting up a trust, protecting the house. But what we do, just because it says elder law in the name, doesn't mean that we can't do planning for anybody. Because like I said a little earlier, once you're 18, you're an adult, and there are certain types of planning you can do really at any age.
Right.
So, elder law piece of what we do deals with issues that affect elderly, but we deal with all ages and, of individuals, whether they're younger looking for planning or they're coming in for us to help their parent, or the individual themselves is looking to plan, for the future or for retirement.
And if I'm correct, your firm actually does a lot of free seminars that people can do right over the computer, and or I guess they can go live if they want, but to just learn some of these topics, what might be or might not be applicable to their lives or important. So the firm is the Cona Elder Law. Where are you located?
We are located in Melville. We also have an office in Port Jefferson. Education is huge for our firm. We like to educate people because unfortunately there is a lot of misconceptions and misinformation out there. And so many times I have people come in and say, my friend told me this and it's not correct, and we can help them, or they think, I can't get something or I can't do something. And we tell them, no, yes, we can. Let me tell you how, and we'll help you. We do a lot of seminars, webinars. You can go on our website and look it up to see if it's something of interest.
Right. And one thing I didn't know is that you could, your point about being 18, you can go ahead and start. There are some things you can do. I didn't know that. So I'm guessing that if you make a will or something at 18, you probably need to come back to you at some point in life. Can you tell us about some of those? Like, how often should we come back to revisit our life plans?
So we recommend review every 3 to 5 years. Not everybody does that. What, I tell people is when you have big life changes, maybe you want to, if you don't, it's not every 3 to 5, but when you're young, you do a will, you have children, you're going to name a guardian. But now your kids are older, they're over 18, you've acquired more assets, maybe you want to set up documents a different way.
Right.
Or now you're thinking about retirement and you're looking to plan for asset protection in the event, you retire or you might need care in the future. So different stages of life, every 3 to 5 years, doesn't hurt. It's better the more you look at it. Sometimes I'll have people come in and say, I did my will 20 years ago. I think it's time to update. My children are grown now. I have grandchildren. So, we do a complimentary review every few years for our clients just to go over everything, make sure it's as they wish. If you don't need to update anything, you don't need to update it, but it makes you kind of look at it to just that it's in the back of your mind, because sometimes people forget. They might name a relative or a friend that passed away or they don't speak to anymore, and maybe they want to change some things as well.
Kristi and Stacy, I've already said today I'm a troublemaker, so I'm going to make a little more trouble. Suppose somebody doesn't have a will, and I don't want to pay that lawyer money to do a will, or I just don't have time to do it. I'll just write a little letter out that says I want everything to my wife and the rest to my girlfriend. And, you got that joke. Okay. So what happens with stuff like that?
That's not going to work.
No.
Ooh.
So
there goes my girlfriend.
Yeah.
You're out of luck.
So New York has requirements of how what a will has to have in it, how it has to be witnessed, how it has to be signed. So, if it doesn't meet those requirements, it's not a valid will. If you die without a will, New York state law says how your assets go. So your girlfriend, unfortunately, would not inherit at all in that case.
So I'm just trusting New York state law. If I don't have a will, whatever the law says, that's the way it's going to be distributed. Even if I'm making a joke of this, but if I don't like my wife, I don't want it to go to one of my children, or maybe one child is wealthy, and the other one really needs the money. If I don't do it, they're kind of stuck.
Correct. So if you die with assets in your name alone, and you don't have a will, we have to file.
What is that called?
So that is called an administration proceeding.
Okay.
When you have a will, it's called a probate proceeding. When you don't, it's called an administration proceeding. It's very similar.
Yeah.
But the law says we have to follow New York state law if you die without a will. So, your spouse and children are first to inherit from you. So in your case, if you said you wanted to disinherit one child, or one is wealthy and they don't need it, the only way really to do that is to make sure you have a will. Or
even a charity or something,
right.
or a brother. Or
a will or a trust, other documents in place to make sure your estate plan is going to go the way that you want it to.
That's a great point. I think is that an intestacy when the original will?
Yep.
So it's a great point, because I think a lot of us forget that. And all the money we made, even if it's not a substantial sum over our lifetime, saved, put away, put in an IRA, etc., we just left it up to New York State or whatever state we're living in to make that choice. And I don't think most of us really want to do that.
Right. If you do beneficiary designations on things, that's one thing. That would follow the beneficiary designation. But if you have a bank account or an asset in your name alone and you don't have any beneficiary on there, or it's not joint, you have to follow what New York state law says.
Right.
Kristi, you've been amazing, and I want to thank you so much. Very quickly, tell us again the name of your firm and where we can find you.
Sure. We are Cona Elder Law. We are located in Melville and also Port Jefferson. You can call our office, 631-390-5000, if you'd like to come in for a consultation. If you have any questions, please feel free to reach out to us.
Our guest today has been Kristi DiPaolo. She's the Senior Associate at Cona Elder Law. Kristi, thanks so much for being with us.
You're very welcome. Thank you so much for having me.
I'm Bill Horan. I'm here with Stacy Raine. We want to thank you for listening to this week's episode of My Hometown.
We like to get your feedback on My Hometown. Send your comments to WHPC@ncc.edu. Nassau Community College, where success starts and continues. Till next time, this is Bill St. James. And remember, there's no town like your hometown.